Welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner at WR Immigration in San Diego, and I am joined with co-managing partner of our Boston office, Miki Matrician. How are you today, Miki?
Good, I can. Yeah, so for today's installment of Rapid Fire Wednesdays, we wanted to cover national interest waivers as a way to avoid PERM. So we got a follow up question from our last session on election, where an HR immigration lead from a company with a few hundred foreign nationals that asked us, should we be more conservative when evaluating national interest waiver qualifications given the presidential elections coming down the pike? So, not to talk or, focus on politics, but because we like to strategize with our clients and there is a presidential election heading our way in the next few months, what are your thoughts, Kimberly, with proceeding down this path of national interest waivers for those who may be eligible?
Yeah, so it was a really good question, and it had been on our minds as well, right? So politics can and do often come into play when we're dealing with immigration status, even employment-based immigration. And this election is, heating up with immigration issues. So as we had mentioned during our June 19th Rapid Fire Wednesday, if there is a change in administration, the leniency that we have seen during the Biden administration may very likely not extend into a new administration. So, to the extent possible, especially given that it can take a few months to prepare an NIW petition and then several weeks or longer for it to actually be adjudicated by USCIS, now is a good time for HR and global mobility professionals to assess whether or not the company will support NIW petitions and also determine, what foreign national employees may be qualified to try to get an adjudication in and completed before a new administration if that is the outcome in the election this coming November.
Yeah. Okay. So now that we've gotten that first question taken care of, let's step back a little bit and provide the background for everybody. So, as we've covered in previous episodes, PERM labor certification is the first step in the three-part green card process. And it can be a really expensive and labor and time intensive process for employers. And on top of that, the government processing times at the Department of Labor, that's the agency that's responsible for PERM labor certifications, has gotten longer and longer. And so those two factors combined have led many employers to think about the national interest waiver category as a good alternative to PERM. So, yeah, Kim, can you talk a little bit about the data that you found?
Yeah, absolutely. And I'm going to use my cheat sheet here because I didn't memorize our statistics. But when we were looking at the USCIS data, what we found was that from fiscal year 2022 to fiscal year 2023, the filing of NIW cases increased from 26% of all EB2 in fiscal year 2022 to 43% in fiscal year 2023, which is almost double if we do our math properly. So, as a quick note, EB2 refers to employment based second preference, which is the category for both national interest waiver and for some PERM applications. So now back to some more useful stats. Conversely, what we saw was that the I-140 petitions in EB2 in the non NIW category dropped from 74% to 57%, which shows that more employers are filing NIWs in lieu of the non NIW EB2s, which would be PERM. Basically, it went from 62,000 to about 53,000 cases. Big difference.
Yeah, totally. And I think this is, partially due to the fact that in early 2022, USCIS updated its policy to clarify how some STEM professions can be eligible for national interest waivers. And also, although we haven't reached the end of fiscal year 2024 yet, we would imagine that for this year, the national interest waiver filings will be in the record high, right? Given that especially in late 2023 as well, the Biden administration issued an executive order signaling kind of an expansion of employment based categories that specifically relate to AI. So, STEM and AI, all of these really have led a lot of employers to consider national interest waiver cases, in some cases, EB1 cases, which we'll address in future episodes, where employers might not have thought of as an option before.
Yeah, that's right, Mickey. So let's look at the NIW criteria. Can you explain to us what the first criteria is all about?
Yeah, so basically, the foreign national has to show that they're doing the kind of work that's in the national interest. So the first kind of technical requirement is that the work has substantial merit. That's the term that's used. So, what does that really mean? It means that the work has to have the promise of bringing a benefit to society. So, in other words, the work has to contribute some improvement to something important in the United States.
Yeah, so I can think of a lot of things that people might think will bring some type of improvement to something important in the US, but we're going to talk strictly immigration here in the immigration process. So, Mickey, can you give us an example what this would look like for our HR professionals to assess?
Yeah, so I guess the easiest example would be like a scientist who's doing research in biotech to develop a cure for a particular kind of cancer. That's like the easiest example I can think of. But, that said, this isn't limited to anything like that, right? It's an area for lawyers to really dig deep and get creative with HR and global mobility professionals. Just as an example, let's say we have a foreign national who does engineering research and uses machine learning to come up with statistical or informational models for a software company, let's say in the construction industry. There could be a really good argument that that employee does work that has substantial merit because of the way in which that work enhances the efficiency of the construction process, for example. And so I think it's really our job as lawyers to tie the work to something that benefits the US. And there's a lot of room for creativity and for good lawyering here.
Yeah, so that's one of the fun parts of our job is noodling through those. So that was the first criteria. So, Mickey, what's the second criterion for NIW?
Yep. So the other thing that's really important is that the foreign nationals' work has to have national importance. So that means that the benefit to society can't be just local or regional. It really has to be national in scope.
Right. So the term of art that we use for the foreign nationals work is proposed endeavor, meaning that this work can be in progress, right? So it's forward looking, which is the green card process. It's forward looking, right? We're looking in the future. It's the other side of that. We have to look at the foreign national who needs to show that they are very well positioned to carry out the endeavor. So what that means is that the foreign national has a record of accomplishments that relate post work that we discussed and that have substantial merit and national importance.
Exactly. And so that means, as another example, if the proposed endeavor is, let's say, developing a vaccine for COVID, but for the past record of accomplishments, the foreign national has been doing research for a cure for a particular kind of cancer. That doesn't really work for an NIW because the proposed endeavor and the foreign national's past work are not really matched. It's not aligned. Also, the other thing to know is that the foreign national also has to have either exceptional ability or an advanced degree or equivalent. So but the equivalent could be a bachelor's degree plus 5 years of experience.
Right. So, Mickey, how do you suggest HR and global mobility professionals go about exploring this NIW for their foreign national population?
Yeah. So I think it's first important to know that not everyone's going to be eligible for the national interest waiver category. In fact, depending on the company and the industry, it would probably be a small percentage of people that would qualify. It's also important to communicate that to the foreign national population because, maybe they hear that their colleague or friend at the same company has been sponsored for national interest waiver or an EB1. And, they think, oh, well, if my friend got it, then I should be eligible too. So I think it's important to communicate that it's a case by case and that the evaluation has to be really fact based. I would also recommend that if you plan to, include this in the HR or immigration policy at the company, you make it clear that sponsorship of the national interest waiver or other achievement based categories is going to be at the sole discretion of HR or global mobility team, depending upon, that case by case determination with legal counsel. And the other thing I would say is that HR or global mobility should work with legal counsel to come up with some sort of parameters for who would be evaluated for national interest waiver or achievement based case. For example, based on a review of the population and maybe business units or certain roles that may, make the most sense for evaluation. For example, for a biotech company, maybe you focus on research-based roles. Or maybe you set up a threshold like certain people who have done certain activities in the past, like, in that biotech example, people who have published at least 3 papers or something like that. That's just an arbitrary number, but for the company and legal counsel to come up with some sort of threshold. And so obviously that's gonna depend on the industry and the company. So it really is about partnering, HR and global mobility to partner with legal counsel to kind of go through all of this together. And so, I do think it's all about selecting certain situations that could qualify for national interest waiver and that are most likely to be approved.
Yeah. So another thing that we were discussing for global mobility and HR professionals to consider is that NIW is a category where the foreign national can self-sponsor, right? Is one of the two where they can self-sponsor. But if a company is paying for the legal and or the filing fees, we typically recommend HR professionals to consider filing with a company as the petitioner, especially if the company is signing off on the support letter and discussing the significance of the foreign national's work at that particular company. So those are some things to consider as well. But given the lengthy quota backlog for certain individuals, especially those who were born in mainland China or India, what are some of the benefits for HR and global mobility professionals to consider when assessing an EB2 NIW as compared to a PERM-based EB2 case?
Hmm. That's something that's definitely important to consider. So, with national interest waivers and individuals not tied to a specific title or occupation, which would be the case with a PERM, instead, the national interest waiver is tied to their proposed endeavor. So, essentially, their field of expertise. And so, therefore, there's more room to grow in their careers and progress without having to file another I-140 petition or PERM application for every kind of substantive change in their career progression. So, in a way, it's so much better and so much more flexible than having to, deter career growth and stay within that same occupation that was sponsored for the PERM or I-140, or in the alternatives for the company to spend more time and money on a new case.
Yeah. So what about portability? So that's when a foreign national moves from one employer to another. Of course, it's never fun to lose a good employee. But what about gaining a good employee, Miki? How could an approved NIW I-140 petition be helpful for the HR global mobility professional and their team when they're assessing and or onboarding an individual?
Yeah, it could really be helpful for HR and global mobility for sure. Gaining an employee that has an approved self-petitioned I-140. So if in that case, if an individual has that approved national interest waiver I-140, but is quota backlogged, when they move to that new company, a new I-140 doesn't necessarily need to be filed as long as they continue to work in that same field of expertise. So their same proposed endeavor as submitted in the approved I-140 petition under the national interest waiver.
That's a good benefit.
Yeah. All right. So I think that about wraps it up for today for us. So join us next week for discussion about avoiding PERM by pursuing the permanent residence process via the EB1A for extraordinary ability or the EB1B outstanding researcher.
Right. And if you don't already, please follow us on our LinkedIn page for WR Immigration as well as our individual profiles. And we also transcribe this Rapid Fire Wednesday into a weekly newsletter that you can subscribe to. So the link to subscribe will be in the comments. So have a great week and good to see you again, Miki.
Thanks, Kimberly. See you soon.